I'd like to share with you some of the more common mistakes real estate investors make when they're using entities to protect their assets. The way I look at it is, why not take advantage of this information? Learn from the mistakes that other people have made so you yourself will not make those same mistakes when it comes to protecting your own assets. For example, I'll start with land trusts. You know, a lot of people set up a land trust for several different reasons. Some want to avoid due on sale clauses. Some want to ensure that they have privacy for their property. Now, most of the people that set up land trusts for privacy, what I have found, do not quite understand how to go about achieving full privacy, or if they do achieve it, making sure that their assets are still protected. Because there's a lot of people out there that talk about land trusts, but they don't explain the details. Take the example of one of my clients in New York. He thought that he could obtain privacy by using a nominee trustee. Now that does work, but provided you choose the right person. He chose his friend. Well, his friend was nominated this nominee trustee in all of his property, so every property was titled in his friend's name as trustee of a land trust that he created. But all of a sudden, his friend decided at some point in time that he was going to become a tax protester, and he quit paying taxes. So what did the state of New York do? They looked up wherever his friend's name appeared, and they liened all those properties. Just so happens that it was my clients whose properties his friend's name appeared on because he was the nominee trustee on those properties. So as you can see, that can be a problem for you when you're using land trusts. If you're looking for anonymity, never use your personal address for tax statements. I mean, think about this. You set up a land trust, you have a nominee trustee on there, and then when it comes to determining where you're going to send your tax statements, you send them to your house. Now, that doesn't make a lot of sense because if somebody's looking, they may not see your name on title, but they will see that the tax statements for that particular property are being sent to your personal residence. So I think it's fair to assume that the person who's receiving the tax statements is probably the person that owns the property. So land trusts, when you're setting them up, you have to be aware of what you're trying to accomplish and making sure that it's done the right way to ensure that you're going to obtain the protection. For example, if you transferred it into a land trust hoping for to avoid the due on sale clause and to obtain asset protection, don't make the mistake of not assigning your land trust to a limited liability company. I've seen it happen before. People set up the land trust, they set up an LLC, but they never put the land trust into the LLC. And then when the lawsuit occurs, they sue the trust, and then they go after the beneficiary. And the assignment was never completed, so it's the individual who remains liable on that particular trust. So you got to be careful. Make sure you're doing all the necessary paperwork to protect your assets. Other problems you have with running business entities is not having bank accounts. You know, every LLC that you create or every corporation needs to have its own bank account. If you don't have the bank accounts set up, then how can you have a business? I had a client did something like that, set up a bunch of LLCs, told her she needed bank accounts for each of the limited liability companies. She didn't listen. As a result, when a lawsuit struck one of her entities, they looked at everything as one common enterprise and took all of those assets. So be careful. Make sure you're setting it up the right way with the proper number of accounts. Also, make sure you sign on behalf of your entity. Don't ever sign in your personal name. If you set up a business entity, if it's an LLC, make sure you sign as manager if you happen to be the manager. If it's a corporation, you're signing as either an officer or in some cases it might be a director of your corporation, but do not sign personally. Because when you do, when you enter into a contract with someone and you put your name on the dotted line and you do not designate your position within that company, then you become personally liable. And so when the seller is looking to sue someone because you've backed out of the sale because the house flooded and you have to close in 5 days and you don't want to close, but the seller told you if you do not close in 5 days and come to the table with the $1 million you agreed to pay, he's coming after you individually, then you'll realize the mistake you made by not putting your designation behind your name when you signed that purchase and sale agreement. That happened. So signing is extremely important when it comes to dealing with real estate. Now, purchase and sale agreements. Let's say you're going to buy a house and that house was under a rehab and you are taking over that rehab project for someone else. Make sure in your purchase and sale agreement that you're obtaining everything you see on the property. List out all of the materials that happen to be there, all the appliances, because the last thing you want is that rehabber that you're buying the property from to take that stuff and leave. Because if you didn't include it in the purchase and sale agreement, well, technically it's not yours as the buyer. Also, make sure when you're looking to buy property to rehab that the property itself can be permitted for the work that you want to do. I've seen clients that have had this problem. They put in serious money only to lose it because they cannot get the property permitted for the rehab work that they intended to do on the property. So that can be a problem. How about joint ventures? I know a lot of people don't want to get involved in joint ventures. You may be the money man, and the other individual happens to be the contractor, somebody who's going to do the work. Well, if you're putting all the money in, have you put together an agreement that spells out what happens if the other party doesn't do their work? Recently dealt with someone. This is the issue. He was going to put in $1 million, and the other person was going to contribute his services plus $250,000 for this development. I asked him, I go, what happens if the contractor dies? Well, he didn't have an answer for me. I said, further, what happens if the contractor does not contribute the $250,000? Do you know if he has the cash? Have you seen proof of funds before you enter into this deal and you buy the property itself that you intend to contribute to this joint venture LLC? Better yet, do you know if the contractor might have to borrow against the property, and have you taken steps to prevent that from occurring? Or have you run a credit check on the contractor to make sure that his credit is decent enough so there aren't other lien holders out there that may come down in the middle of this project and put a stop to it because they're suing the contractor, he picks up and leaves. These are situations that you have to look into before you go into business with someone else. And so many people make mistakes by not dealing with the tough issues at the outset, only to end up in litigation at the end. That's not where you want to be when it comes to joint ventures. So the real estate, there's a lot of different issues that can come up when it comes to investing. Most time it comes down to people not putting together the proper operating agreements for their real estate investing, meaning they set up an LLC, but they don't have an operating agreement to back it up that really matches what it is they're doing. For example, does your operating agreement allow you to engage in competing ventures? It seems like a technicality, but it could be important. If you have multiple LLCs set up all to own real estate, the first LLC operating agreement doesn't allow you as the member or manager to go out there and put deals together for other LLCs, even though you own them. Then everything can be treated as owned by that first LLC if somebody were to attack it. Little things do matter when it comes to creating these agreements. How about if you have a limited liability company, it requires that you take distributions on an annual basis. I can't tell you how many times I've seen LLCs where it states that the members will receive a distribution on an annual basis. The operating agreement forces distributions. That sounds fine until you are sued individually and somebody puts a charging order on your LLC interest, and then you don't want distributions any longer, so you try to stop taking them because you don't want them to go to your creditor. At that point, it's too late because your operating agreement states that you have to distribute the money on an annual basis. So take it from me. I've worked with thousands of clients all over this country. I've seen what works and what doesn't. And the problem is that when you find out what does not work, many times that can be a very expensive lesson. So do it right at the beginning, and you don't have to worry about it at the end.